There were several petitions for a rehearing on the matter between the Koontz Brothers and the creditors of Elkhorn Coal. There were certain questions that had to be answered on the decision that was filed with the court on June 5th, 1951. These motions were filed on the behalf of the Koontz Brothers as well as Harry W. Eliers and others. Will this judgment stand or be reversed by the Ohio Court of Law? All aboard the Kentucky Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. The petitions of Harry W. Eliers and others. At first, the motions and petitions of a rehearing filed by Harry W. Eliers and others was denied. However, there was an order that was placed with the court where their concerns would be addressed and recognized. It was agreed that certain modifications of the court's first decision needed to be made in respect to questions posed by their side of the case. The case now before the court. In the first decision prepared by Judge Lovings, which was filed on February 14, 1950, there were certain fundamental questions answered between the stockholders and Elkhorn Coal Corporation on one side and the Koontz Brothers on the other side. Because of this ruling, the Koontz Brothers' common stock sold to them by the estate of Clarence Watson had to be placed aside because they were prejudiced against the Elkhorn Coal Corporation. The case was sent to the Circuit Court of Ohio County for entry and decree. Creditors of the Clarence Watson estate filed petitions with the court because their claims were not heard against the estate. According to the petition, they were also not heard in the case before the Circuit Court of Ohio County. Because of potential injury to these creditors, their questions and concerns were now being addressed. Agreement on 2 points of law. For the first time, both sides of this case were in agreement about 2 crucial points. These points can be found in the Justia Law article. Quote, 1. That this court, in its opinion filed June 5, 1951, has departed fundamentally from the decision of February 14, 1950. And second, that Elkhorn is entitled to preference in the payment of the proceeds of any sale of the 38,000 certificates not covered by any collateral agreement, but as to which Elkhorn was a common creditor of C.W. Watson, unquote. The court also recognized that it was an error by not recognizing the claims of the other creditors and that it should have prompted the lower court to take some notice of them in its decision about the stock certificates. That indeed the other creditors should have been allowed to be heard and the validity of their claims addressed when the decision was handed down. However, the court did not believe that it was proper to permit the disposal of the certificates by sale or other disposition, and that all valid claims by the creditors should be entitled to a share of the benefit of the distribution of said monies. The court had previously taken the position that the creditors' petition in the lower courts was not confined to the 38,000 shares. Even though Koontz Brothers claimed the 60,000 shares was due to them because of their deal with the Clarence Watson's estate before his death. However, the 60,000 certificates, according to the court, was now part of the Clarence Watson estate and could not be changed after his death. The court then went on to state that all creditors will lose their rights to a part of the distribution of the monies if they did not file their claims to the court by the set deadline. Because of this, the only creditor that did file on time was the Elkhorn Coal Corporation in the probate court in the state of Ohio. Therefore, the corporation is the only creditor allowed to benefit from the sale of the 28,000 stock certificates. There were 2 reasons given in the Justia Law article. Quote, First, we are not, at this time, fully advised on the force and effect to be given in this proceeding to the Ohio sale. We give full faith and credit, of course, to the sale made in Ohio, insofar as it passed legal title to Koontz of the certificates involved, and this we have always done. The other reason for reserving the question is that it is a question of priority, as between Elkhorn, admittedly a common creditor of Watson, as to the 38,000 certificates, and the other creditors who are now asserting their claims, but who have yet not established such claims as against said certificates. Unquote. In other words, first the claims of the other creditors must be proved to be valid before they can claim the part of the distribution of the money. And second, the upper court modified and corrected its stance upon the creditors, and their claims must be sent to the lower court in remand. This had to be done this way so that there was no delay in granting of the rehearing of the case. In next week's video, we will cover the annotated case concerning the mineral rights of Elkhorn Coal Corporation, and also discuss how all of these court cases led to the sale of Elkhorn Coal Corporation and Consolidation Coal Company to Beth Elkhorn Coal, and the sale of property to residents and businesses in the counties that Elkhorn Coal Corporation and Consolidation Coal Company did business. Thank you. Kentucky Tennessee Living would like to thank you for watching our video series on the scandals of the Consolidation Coal Company. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.